Assalamualaikum, my name is Wanur Shafiqah. My metric number DIL201030, and I will proceed for the definition of squatters. Squatters can be defined as unwanted people settled in other person known as the landlord or the property owner without our consent. To deepen the word squatters, it can be briefly said that those who occupy, tenanted, live in someone else's property without having the right of the property, as well as does not pay for the rental upon the property, upon the use of property and permission of the owner. These people who decided to occupy the land or property usually does not have an authorization, and most cases happen without the knowledge of the property owner. In the case of Bukit Lenang Development Sdn Bhd, against penduduk-penduduk yang menduduki atas tanah Mukim Plentong, daerah Johor Bahru, which is 6 MLJ 26, squatters were defined as a person who enters upon another's land and remains thereon to the detriment of the present owner is trespasser, pure and simple. On the other hand, in the United Kingdom case of Makefield against person unknown, squatters were defined as he is one who, without any colour of right, enters on an unoccupied house or land, intending to stay there as long as he can. He may seek to justify or excuse his conduct. He may say that he was homeless and that this house or land was standing empty, doing nothing. But this plea is of no avail in law. Next, hence, squatters can summarily be understood as individual and or person who occupy another person's land and or premise illegally without any valid claim to the legal title or rights toward the land, without making any form of monetary payment to the owner of the land and without the lawful permission or consent and or knowledge of the owner of the land. I think that's all from me. I will proceed to the next presenter.
Thank you, Shafiqah. Assalamualaikum and a very good afternoon to Madam Asna and my fellow friends. My name is Amshar Naimani binti Muhammad Khairul Amru and my matrix number is DIL201028. So today I am going to present about the referred case for the definition of the squatters, which is Bukit Lenang Development Sdn Bhd and also penduduk-penduduk Mukim Plentong. The facts of the case are as follows. The plaintiff entered into a sale and purchase agreement with Oakfield Enterprise Sdn Bhd to purchase certain lots of land. Oakfield then notified the plaintiff that unknown person had unlawfully entered the lots and occupied them without license or consent from Oakfield. Oakfield then had obtained a court of order and also the writ of possession to remove the trespasser, but the attempt was unsuccessful. It was submitted that neither plaintiff nor Oakfield had given consent to the defendants to stay there. The defendants argued that they had paid 3,000 ringgit Malaysia each to Oakfield as deposit for their lots. The payment were made alongside with the pro forma of the purchase entitled Borang Permohonan dan Pengakuan Minat. So the issue here is whether the defendants were licensee or mere squatters. It was held that the parties, namely the Oakfield and the defendants, did not constitute any legally binding contract but merely guideline to the defendants on the sale and purchase of the lands. It was said a mere expression of the defendants' desire to purchase subject to various conditions which remain unfulfilled. Order 89 of the Rules of the High Court 1980 was raised. However, it was found that the defendants did not come within this exception. Quoting from the judge of the case, which is Zainul Ali J, a person who enters another's land and remains to detriment of the present owner is a trespasser. In this case, when the plaintiff become the registered proprietor, the defendants become a mere trespasser. The defendants had failed to establish the existence and thus become a squatters, simply cited and therefore not possess any rights. That's all from me. I'll pass to next presenter.
Hi and Assalamualaikum. My name is Raha Izzati. My metric number is DIL201043 and today I'm going to be presenting about possession. Possession of real estate often entails being present on the property. Possession conveys the most direct factual relationship that may exist between a corporeal item and the person who owns it. Possession is defined as the detention and control or manual or ideal custody of everything that may be the subject of property for one's use and pleasure, either as the owner or as the proprietor of a qualified right in it, and held personally or by someone who exercised it in one's place and name. Possession is essentially defined as an actual occupation and may be held regardless of the ownership or title. A mortgagee does not have ownership but may have possession, while a future interest holder has a type of ownership but does not have possession. Possession is a reality that may or may not be legal, but ownership is a legal right that is recognized and protected. Possession is not defined exhaustively in English law since it relies on the circumstances and the thing or right that is claimed to be someone's possession. However, the following concepts have been established. The first concept is the formalized phrase, which is in the absence of evidence of the contrary to the owner of land with paper, the title is deemed to be in possession of the land and the person with the prima facie right to possession. The second concept is the law to attribute possession of land to a person who cannot ascribe paper title to possession. He must be shown to have both factual possession and the required side information to possess. The third concept is a factual possession signifies an appropriate degree of it must be single and conclusive possession, yet single possession may be exerted jointly by or on behalf of multiple people. As a result, an owner of property and someone encroaching of his land without permission cannot both be possession at the same time. It is well established that actions of possession performed on portions of property for which a possessory title is sought may constitute proof of ownership of the whole parcel. Adverse possession is a legal phrase that describes a person, often known as an unlawful squatter, who occupies a piece of property without the knowledge of original proprietor and ultimately acquires legal title of the land via continued use and use of the land. As a result, anyone with access to your property can literally squat into your background with or without your knowledge, build an abode for himself, or extensively renovate it and claim that your backyard now belongs to him after a certain number of years, if you do not chase him away before his rights take effect. The requirement of proving adverse possession vary by jurisdiction. In many places, documentation of payment for property taxes and a deed are necessary for the claimant to be successful. Each state has a limit within which the landowner of record may invalidate the claim. For example, if the state threshold is 20 years and the landlord pays for the other upkeep on the dwelling issued in the 19th year, the claimant may struggle to prove adverse possession. Having stated that, landowners are recommended to eliminate the danger of adverse possession as soon as possible by signing agreements for any usage of an owned property. And I think that's all for me. I hope you learned something and I'll pass you to the next presenter. Thank you.
Hi and Assalamualaikum. My name is Shala Shaira binti Nizam. My matric number DL201031. So my part is, does Malaysia have adverse possession? Malaysia doesn't recognize adverse possession. When the British were in our country, there used to be a law called adverse possession. Ironically, the law itself comes from Britain, but they themselves eventually abolished it here. Basically, this law allows someone to take over your land and legally make it yours if you had left it vacant for a long time. This law eventually came to Malaysia, but it's been abolished, especially after the National Land Code came into effect. People did try to claim adverse possession even after that, but the courts rejected them. To justify it, in Revolusi Rancak Sdn Bhd against penghuni-penghuni yang tidak dikenali in 2019, the court explicitly emphasized that squatters are trespassers and do not possess any right on the land. Moreover, our law, specifically the National Land Court, has clearly emphasized on the position of the adverse possession and does not recognize. So that's all from me. Thank you.
Assalamualaikum, my name is Nur Izzati Nadia binti Ahmad Karim. My entry number is DIL201025. I will be presenting about the squatters' right in Malaysia and Section 48 of National Land Code. Squatters by definition are persons who occupy someone else's property without holding a title, a right, or without making payment of rent. They are simply people who have occupied land or property without permission and in most instances without knowledge of the property owners. Malaysia has been grappling with the squatter issue in the face of increasing urbanization since 1980s. The law in Malaysia is clear. Squatters have no rights either in law or in equity, a statement supported by Section 48 and 425 of the National Land Code 1965, as well as the case of Siddiq bin Haji Muhammad and ORS versus the Government of Malaysia, which confirms squatters have no rights in Malaysian law. One common challenge in managing the issue of squatters is that they would often avoid disclosing their identity. Thus, proprietors are often clueless as to the identity of squatters on their land. The eviction of these unknown persons can, however, be done through a summary proceeding, omitting the need to identify the identity of squatters. Order 89 of Rules of Court 2012 provide for possession of land through summary proceeding. Several elements need to be established by an applicant to justify the application. 1. His interest in the land or premise. 2. The circumstances of how the land has come to be occupied by the squatters. And 3. Inability to identify the persons occupying the land and the reasonable steps taken to try to identify those individuals. Court will, upon satisfaction, order for possession in proceeding and therefore issue a writ of possession to enforce the said order. In other words, the summary proceeding bypassed the need to individually identify the squatters or defendants. However, it is to note that Order 89 summary proceeding is not applicable to a tenant holding over or a tenant who remains on the property after tenancy being terminated. As such, a squatter currently neither has legal or equitable rights over the land that they are occupying. Occupation of state-owned land is a crime punishable by a fine up to 10,000 ringgit or 1 year in imprisonment or both. Moving on to Section 48 of the National Land Code, or also known as NLC. The law is clear in Malaysia when it boils down to squatters' right. The National Land Code 1965 is one of the go-to statutes when discussing their rights. However, it is important to note that said statute is not very favourable to squatters themselves. This unfavourability is particularly highlighted by Section 48 of the NLC, which expressly state that no title to state land shall be acquired by possession, unlawful occupation, or occupation under any license for any period whatsoever. The plain and simple reading of the statute highlight that the word and or term squatters is not used. However, in turn, the NLC uses the term unlawful occupation when dealing with squatters. The provision also expressly set out that unlawful occupation of state land, even after a long duration of occupancy, does not automatically enable the occupier to obtain title to the land. What this comes to show is that Section 48 makes it crystal clear that the only way for one to get the land title in state land is through the formal application via the NLC. The law on squatters when it comes to state land is generally very strict and there is little to no room to maneuvering it. That is all from me. Now I will pass it to the next presenter. Thank you.
To Izzati Nadia. Hi and Assalamualaikum to Madam Asna. My name is Yasmin Hanani binti Samsuddin and my matrix number is DIL201033. So before I go further to explain the case of Siddiq, I would like to explain a little bit about the section 341 of National Land Code 1965. This section indicates that the real or original owner shall have the rights repossess their land notwithstanding the period of the possession by the illegal or unlawful proprietor. This might come to the relief of many landowners who may no longer reside on their land or landowners who are overseas and therefore may not notice nor have any active knowledge of the illegal occupiers on their land to take the necessary immediate actions. So next, I will continue with the case of Siddiq and ORS versus the government of Perak. So, in this case, some of the appellants came to Teluk Anson from Kedah, North Perak and Selangor and opened up a large part of the jungle area. There were squatters and later other squatters joined them. There was a meeting between the squatters and government officers in which it was alleged that the State Director of Lands and Mines said that each settler family would receive 5 acres of paddy land. There were also an article in Utusan Melayu quoting Bernama as the source, stating that the government was prepared to open up about 10,000 acres of land to be developed by the squatters. Eventually, some of the squatters were given 3-acre lots, but others, including the appellants, were not successful. The appellants were given notice to stop work and to vacate to vacate the area. So in this case, it was held that it is clear beyond doubt that the appellants have no cause of action against the respondents and they cannot succeed because they are squatters. Squatters have no right either in law or in equity. An illegal occupation of state land is an offence under the Section 425 of the National Land Code 1965. It is well established that a court of equity will never assist squatters to resist an order of possession illegally acquired, and it will never intervene in aid of wrongdoers. In this case, what was said by Bernama did not bind the government. Neither did the State Director of Lands and Mines have authority to bind the government to alienate land to the squatters. Last but not least, the only way to obtain state land is by way of the National Land Code. The case falls within the broad principle that where an act creates an obligation and empowers the obligation in a specified manner, it is a general rule that the performance cannot be enforced in any other manner. That is all from me. I will pass to the next presenter to continue this presentation.
Assalamualaikum. Hi to all my classmates, and do not forget to our respectful and beautiful lecturer, Madam Asanisa Armasnan. Before I start my part, my name is Nurul Hamidi Zainal, my matric number DIL201020. To continue with our presentation, I would like to talk about remedies. Order 89 of the Rules of Court 2012. Landed property ownership is permitted and protected under the law. Therefore, Malaysia was practiced thorough system which is registration is everything. The normal benefits and drawbacks come with such ownership. The problem arises when a third party reclaims control of the landed property. Fortunately, when that happens, the law provides recourse to the owner of the landed property concerned to evict such unwelcome guests. One such legal recourse is by way of summary proceedings under Order 89 of the Rules of Court 2012 Order 89. This article intends to explore the scope of applicability of Order 89 as a legal means to regain possession of landed properties occupied by unwanted third parties. Next, for the functions of Order 89 ROC 2012, firstly, allow landowners the benefit of summary proceeding to regain possession of landed properties occupied by unlawful third parties. Secondly, can resort to legal proceeding as a remedy of self-help. Last but not least, one such legal avenue is open to the owner of the landed property is to apply under Order 89. To address these issues, Order 89 was enacted which established a procedure for initiating summary proceedings for land possession. Order 89 Rule 1 of the Rules of Court states succinctly as where a person claims possession of land which he alleges is occupied solely by a person or persons not being a tenant or tenants holding over after the termination of the tenancy, who enter into or remain in occupation without his license or consent or that of any predecessor entitled of his. The proceedings may be brought by originating summons in accordance with the provisions of this order. It is clearly stated that the proceedings may be brought by originating summons, which means that the matter can be disposed of by affidavit evidence rather than the need to take it verbal voice, which would normally be a protracted and costly affair. Of course, such an affidavit in support of the originating summons must comply with requirements of Order 89 Rules 3. In Order 89 Rule 6 of the Rules of Court 2012 states, once proceedings begin, the hearing for an order for possession shall proceed as a chamber's matter after 5 calendar days from the date of service of the cause papers except for urgent cases, or leave is granted by the court. Besides, the Order 89 procedure is based on a few underlying principles which can be broken down into the following elements of the locus standi to enacted proceedings. Locus standi, a Latin phrase, means a place of standing, at times referred to as the doctrine of standing, determines the competence of a plaintiff to initiate civil proceedings in a court of law against the defendant. Apart from that, the absence of either a license or consent occupied, as well as the principles of summary judgment. Last but not least, I would like to talk about remedies for squatters, as Malaysia no longer recognizes the concept of adverse possession. A squatter neither has legal nor equitable rights over the land that that they are occupying illegally, however long it may be. This was confirmed in C-Date when Haji Muhammad and others against government of Perak, where the federal court dismissed the claims of the squatters and held that a person can only obtain a state land by way of a formal application for land based on the rules and regulations set down in the Code. Any person who unlawfully occupies, cultivates, or even removes produces from such and commits an offence under Section 425 of the Code and can be punished with a fine not exceeding 5,000 ringgit or imprisonment not exceeding 5 years or both. Next, remedies for landowners. The same case, Chief Justice Raja Azlan Shah noted that the landowners do not have an obligation to bring the matter to court for the owner to repossess their own land. The owner can even resort to the use of force so as long as it is reasonable to do so, and he uses no more force than it is reasonably necessary. The landowner also has other options to choose from if he decides to bring the matter to court. For example, the landowner can bring an action for trespass under the law of tort and sue for damages. Secondly, bring an action under summary proceedings for possession of land under the rules of court and obtain an order for possession which may then be served upon the squatters and order them to move out, or enter the land to forcefully evict and demolish the squatter hoods according to Emergency Clearance of Squatters Regulations (ECSR). This can only be done after the appropriate notice is given to the squatter to warn him of the impending eviction or demolition. The primary objective of the procedural law is to make it easy to obtain justice based on substantive law. There is no doubt that Order 89 was created to provide landowners with a simple, quick and easy method of regaining possession of their land from unknown squatters. However, there is no reason why it should be so restricted when the language of Order 89 allows it to be used against other unwelcome guests, such as gratuitous licenses if there are any interest of, then justice will require it. So that's all from me. Next, I will pass to the next presenter.
Assalamualaikum warahmatullahi wabarakatuh to Madam Asna. My name is Karima Jamal and I will be presenting the comments on our assignment. So, what is the best way to settle this squatter problem? Here I've given 2 points. The first point, the government of the day should develop more jobs outside the region in the country. So this makes the squatters want to move out on their own. Like let's say they should build factories outside, more factories outside the region. Let's say in Kuala Lumpur, they should build factories outside of Kuala Lumpur, so that squatters can move out on their own and search their own jobs and they can afford living there. So this also will entirely reduce the squatter problem. Secondly, the government can also run initiative by not just giving them free money like bantuan. No, the government should only give them money after them doing the job. This will also make them more appreciative of the money that's given to them rather than them just taking it for granted. So they know how hard is it to earn that money. So yes, the government of Malaysia has done some initiative to tackle this program through the Selangor Zero Squatter Settlement Program. So in January 1998, the Selangor local authorities wanted to abolish all the squatter settlement that has been built. So the government of Malaysia in 2005 created a program using 5 strategies, which I will cover later, which led up to the Selangor Zero Squatter Settlement Program. So, as a result, from February 2000 to December 2004, Selangor has seen a rise in low-cost housing. So there were 5 strategies in the Selangor Zero Squatters Action Plan. The first one is planning. So basically what this is the government collected data from areas to see how many squatters are there in the area and is it worth it or not to build the low-cost housing. So let's say they will go to Ampang, for example, and they will see how many people here are actually in need of low-cost housing, how many people here are actually living under bridges, homelessness, unemployed. So that's what the first step the government did. The second one is supervision, observing and ensuring that the development of the housing is parallel to other types of housing. So it's not, even though it's a low-cost housing, it doesn't really seem like a low-cost housing. So this is what quality management also the government did. The third step is distribution. To make sure that the quota of the low-cost housing is distributed fairly and especially to the target group. So the target groups are squatters, homeless, and unemployed. So the government did this so that people who are not from that area cannot apply for these quotas for this low-cost housing. The fourth plan is enforcement. So enforcement is anybody who the government will keep anybody who want to fail the plan to make this low-cost housing, the developer. So the enforcement, maybe they have law enforcement to help make sure that this plan goes to what they planned it out to. The last one, not least, housing management. This is to ensure after December 2004, all people in Selangor legally have a home. So whether it will be the target groups, especially squatters, homeless, and unemployed. The second initiative done by the government Malaysia is settlement through low-cost housing. This is what we know as PPR flats. So have you ever seen PPR flats whenever you go by highway? I'm sure in every district you go, there's a PPR flat. That is one of the initiatives, like I said earlier, in the planning. The government planned that in every district in Malaysia, in every state, there are PPR flats. So, but, however, there is a problem. Because now, 1 unit of PPR flats is 30,000 ringgit. People who are squatters and homeless and unemployed, they may not have that much cash in the bank. So at the end of the day, this is a problem also. So because the people that the target groups, they cannot afford, and the government gives loans, but they demand an interest after that. So at the end of the day, the PPR flats are working, but yet it's still expensive for the target group. So in conclusion, there are squatters who are affected financially, socially, and surprisingly religiously. As landowners, we have a right to protect our land from it being taking advantage of the people who do not have even rights to that land, yet they live in that land. So we as landowners, we have to take the rightful steps and the caution to hinder this from happening. Thank you very much for listening to our presentation.